it is understood that an offer is made with a view to obtain the assent of the other person, isn't it? So the offer may terminate or lapse by the act of offerer by revocating, or by the act of offeree by rejecting. Revocation is happening from the uh, offerer point of view, rejection is happening from the uh, offeree point of view. So here, section 5 talks about this, that an offer may be revoked at any time before the communication of acceptance is completed as against the proposer, but not afterwards. So when Usha sends a letter to Yash proposing to sell her land and building, Yashwant sends his acceptance by post. Usha can revoke the offer at any time before or at the moment when Yashwant posts his letter of acceptance, but not afterwards. So revocation is possible only when the communication of acceptance is not completed against the proposer. So it has to be made within the time limit. Another example, what he has mentioned here is Abhishek offers by letter dated 1st January. So 1st January, he has sent a letter to sell his car to Abhay for 1 lakh rupees. Abhay accepts on 7th Jan at 1 p.m. by a letter sent by post. Here, Abhishek, this is Abhishek, not X. Abhishek may revoke his offer at any time before the 7th June. So, if the acceptance is done on 7th Jan, so afterwards it cannot be revoked. It has to be revoked only before 7th Jan. So, in such case, if the revocation is not done within this time limit, then offer cannot be revoked. And another case, an auction sale, when the highest bidder can revoke is offered to buy before the fall of the hammer. So in such case, if there is a fall of hammer, then the highest bidder cannot revoke. Whereas rejection is another case where the offeree may not accept the offer. He may reject the offer. So such rejections can be considered as express rejection through oral or written, whereas implied by making a counter offer or giving a conditional acceptance, wherein it will be construed as implied rejection. And the second reason for lapse of offer is that not accepting within the time fixed. So basically, when an offer is coming to an end after the expiry of stipulated time, in the contract, in the offer, when the offerer is making an offer subject to the time limit for acceptance, and there is a condition to accept within the stipulated time, and if it is not accepted within the specific time or stipulated time, the offer comes to an end. In unique case where there is no time limit mentioned, in a case where there is a no time limit is mentioned, so the offer can be accepted within the reasonable time. Students, here the reasonable time is varies depending upon the facts and circumstances. So we have to be very cautious as to when the time is not mentioned. We have to go by the facts and circumstances of the each case in order to define the reasonable time. So what is reasonable? It is dependent. For example, if A writes to B, will you buy my car for 2.5 lakh rupees? And he has to reply by next Sunday. If this offer is mentioned that next Sunday, within next Sunday it has to be replied, B communicates his acceptance on Monday afterwards. So offer comes to an end on Sunday and A is not bound to B's delayed acceptance. So in such case, the offer gets lapsed considering the lapse of time. Whenever there is a prescribed time stipulated in the offer as a condition, then it has to be adhered to. And the next point where the offer gets lapsed is by the death or insanity of the offerer or offeree. And proposal is revoked due to the death or insanity of the proposer if the because of the fact that the death or insanity leads to null or void. So hence in such case, whenever the offerer dies or becomes insane, the offer comes to an end automatically. Here, whether the person, the acceptor, knows or does not know about the death or insanity is crucial here. If the party or acceptor gets the knowledge about the death or insanity, uh, it will be considered as invalid or void. So the offer remains lapsed. But if the offeree does not know about the death of the person, or if he accepts it in the ignorance about the death or insanity of the offerer, then it will be considered as a valid contract. In the British law or the English law, the death of the offer terminates the offer, even if acceptance is made in ignorance of death. But however, in Indian provisions of law, so the if the offer is accepted in ignorance of the death or insanity of the offerer, it will be considered as valid contract. And moving on to the next rule as to the lapse of offer is to failure to accept the condition precedent. So basically what this means is an offer gets lapsed if it is accepted without fulfilling the conditions of the offer. For example, if Anand offered to sell his car to Yashwant for 1 lakh rupees, subject to the condition that Yashwant should pay an advance of 20,000 on a particular date. So if Yashwant accepted the offer but did not send an advance, in such case the offer gets lapsed because the condition was not fulfilled. So whatever the conditions put forth in the offer, it has to be duly met, otherwise the offer gets lapsed. Another way of lapse of offer is that counter offer, which we have already discussed, that when an offeree makes a qualified acceptance, he is making a counter offer, so which will amount to the rejection of the earlier offer, the termination of the earlier offer. So it cannot be considered as concluded contract. For example, when Anand offers to sell his car for 5 lakh rupees to Vikas. So Vikas counter offers that he will agree to buy for 4 lakh rupees to Anand. So when the original offer is countered with another offer, so original offer lapses. So original offer is lapsed, is terminated. So because of the counter offer. And another reason for lapse of offer is that not accepting the offer in a prescribed mode. Students, you have to remember that when an offer mentions that it has to be accepted in a certain manner, for example, it has to be replied through email only, then it has to be made in such manner. If an offer contains a term that acceptance should be made in the email reply only, if the offer is sent through a letter, it means the offer was not accepted in a prescribed mode. In such case, the offer gets lapsed. And in another situation where no mode is prescribed in the offer, in such case, offeree has to accept in some usual and reasonable manner. If it is not done in a usual and reasonable manner, then it is again considered as terminated. Please understand this. So in offer, if it is not accepted in the specific manner as prescribed in the offer conditions, it will be treated as terminated, lapse of offer. But if the offer does not have the conditions as to the prescribed mode, then it has to be made in the usual mode or reasonable manner. And the last part is that when the subsequent illegality or destruction of the subject matter. What happens generally at the time of making a offer, the subject matter may be legal, but once the offer is made, subsequently, considering the change in law, change in circumstances, which renders the original offer unlawful or impossible, isn't it? So in such case, it will be treated as invalid offer, so which comes to a conclusion that the offer is lapsed. For example, if Prakash offered to supply 100 tons of sugar to Vikas on a certain date. Before this offer is accepted, the central government issued an order which prohibits the movement of sugar. In such case, offer comes to an end because of the illegality if it is continued further. So these are the discussions with respect to the offer, classification of offer, the valid rules, and the lapse of offer. So next we will discuss the acceptance. Acceptance. Acceptance is defined in 2b, where acceptance is nothing but consent to the offer. Consent to the offer. So when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. So when the proposal, when accepted, it becomes promise. So this we have already covered in earlier discussion as to the 2b. When Xavier offers to sell his car to Yasmin for 5 lakh rupees, Yasmin agrees to buy the car for 5 lakh rupees. So Yasmin's act is in acceptance of Xavier's offer. So here acceptance should be in response to an offer. So meaning acceptance is nothing but a consent to an offer. Acceptance cannot precede an offer. Please understand. Acceptance cannot precede offer. So offer is first, acceptance is next. An acceptance is to offer what a lighted match is to a train of gunpowder. Acceptance is to offer what a lighted match is to a gunpowder. It produces something which cannot be recalled or undone. Simply put, offer is nothing but a gunpowder, and a lighted match is nothing but an acceptance. When a lighted match is shown to a train of gunpowder, it explodes and something happens. So in this case, when the offer and acceptance along with the enforceability, it creates a contract. So which cannot be undone, matlab it cannot be broken later on. So see, once an offer is accepted and cannot be revoked, but so long a lighted match is not shown, the gunpowder remains inert and can be removed. Similarly, an offer can be revoked before it is accepted, as we have already covered. So let us understand the legal rules of valid acceptance. So acceptance can be given only by the person to whom the offer is made. So the first valid rule is that it can be given only by the person to whom the offer is made. But if offer is not made to a particular person, and if that person is accepting it, it cannot be called as valid acceptance. So we are referring here to the specific offer. When the specific offer is made to the specific person, it has to be accepted by that person only. Whereas in the case of general offer, acceptance can be inferred from any member of the public by adherence to the terms and conditions of the offer. But in the case of specific offer, it can be given only by the person to whom the offer is made. This is the first valid rule. The second legal rule is that acceptance may be expressed or implied by the conduct. So what happens when performance of conditions of an offer for the acceptance of any consideration for a reciprocal promise which may be offered with a proposal is an acceptance to the offer. Acceptance may be signified either in words or written form, or it may be by the conduct or performance of the parties to the contract, which we discussed in the case of Carbolic Smoke Ball Company, that acceptance may be implied by using the product as per the terms and conditions when the company makes a general offer. So here the express acceptance is one which made by words spoken or written, whereas implied acceptance is one which is made otherwise than in words, meaning it is through the conduct of the parties, which we gave the example that when the bus operator is operating a bus from Bangalore to Mysore, which is standing at the platform, wherever the passenger boards the bus, it is deemed as acceptance, because by the conduct of the passenger it is considered as acceptance. Another very important and crucial rule is that it has to be absolute and unqualified. Whenever the offeree is accepting the offer, it has to be on absolute and unconditional. If the condition is put, or if the qualified acceptance is given, it is regarded as invalid. So you remember that offer may have conditions, but acceptance should not have any conditions, because a qualified and conditional acceptance amounting to a counter offer, which puts an end to the original offer and cannot be revived by the subsequent acceptance. Please remember this. So when Xavier agreed to sell 2 machines to Yasin at a certain price, Yasin accepted the offer for 1 machine. So when the Xavier agreed to sell 2 machines, Yasin accepted for 1 machine. It was held that acceptance was not valid because it was not for the whole of the offer. So here, the Yasin should have accepted for the 2 machines. Otherwise, this has resulted in the counter offer, which leads to the termination of the original offer. Original offer gets terminated. The next important legal rule is that acceptance must be communicated. Must. Obviously, the communication, it may be expressed or implied. So here, mental acceptance, matlab failure to answer or silence on the part of offeree is not acceptance, because it is not communicated. Silence can never be considered as acceptance, because only with his words or through conduct can be regarded as acceptance, but silence we cannot amount to acceptance. For a general offer, no communication is necessary if it is made by acting upon the terms of offer. But for specific offer, it has to be through the express or implied. So there are certain case laws enumerated here. Kindly go through it. In the case of Broaden versus Metropolitan Railway Company, wherein the B, a supplier, sent a draft agreement relating to supply coal to manager of railway company for his acceptance. The manager wrote a letter called approved on the same, and put the draft agreement in the drawer. It was not never sent the communication. It was held that there was no contract, as the manager had not communicated. Hence, no acceptance and no contract. So in another case where Union of India versus Bahulal, A offers to sell his house to B for 5 lakh rupees. B replied that I can pay for 4,80,000, which has led to the counter offer. The offer of A is rejected by B as the acceptance is not unqualified. So B, however, changes his mind and is prepared to pay 5 lakh rupees. This is also treated as counter offer, and it is up to A whether to accept it or not. So this will be an conditional acceptance, which will be invalid. And another case where Bhagwan Das versus Giridhar Lal, where an offer made by the intended offeree without the knowledge that an offer has been made to him cannot be deemed as an acceptance, because offer also have to be made, and without that knowledge, if the offeree has accepted it, it cannot be considered as deemed acceptance. And in Hayworth versus Knight case, the mere variation in the language will not amount to invalidity, meaning a mere variation in the language is fine with that, but it should not involve any major variations or modifications. So mere variation in the language not involving any difference in substance would not make the acceptance ineffective. It means the acceptance is valid even when there is a mere variation in the language. Moving on to the next part, valid rule is that it must be made in the prescribed mode. As discussed earlier, the acceptance has to be given in the mode prescribed as per the offer. If no mode is prescribed in the offer, it has to be made in the usual or reasonable manner. So it has to be, if it is prescribed, it has to be done in the mode prescribed, otherwise in the usual or reasonable manner. So for example, if the offerer prescribes acceptance through letter and offeree sends acceptance by email, so the letter was intended but email was sent, so there is no acceptance, valid acceptance. However, if the offerer informs the offeree that acceptance is not according to the mode prescribed, then it is fine. But if the offerer fails to do so, if the offerer fails to intimate this, then it will be presumed that he has accepted the acceptance and valid contract will arise. So moving on to the next valid rule is acceptance must be within the time limit. So whenever an offer is made with the time prescribed, if no, it has to be accepted within the time prescribed. Otherwise, if no time is prescribed, then it has to be accepted within the reasonable time. So what is reasonable? It depends on the facts and circumstances basis. So an acceptor has to adhere to the specific time limit if time limit is mentioned. If no time limit is mentioned, it has to be accepted within the reasonable time. And the next part is that it must be given before the lapse of offer. In the case of standing offer where the time limit is mentioned, say for example, I offer to sell my car for 5 lakh rupees, and offer closes on Friday 5 p.m. So if the acceptor responds it on Saturday, so the offer is lapsed, so acceptance will not be remained as valid because the offer is invalid, offer has become lapsed, so there is no point in accepting a lapsed offer. And another point is that acceptance should be made with an intention to fulfill the terms and conditions. See what the law is saying, that if the party or the acceptor is not having any intention to perform it, it should not be accepted. So when it is accepted without having any intention to perform, it will not be regarded as valid acceptance. So these are the rules of valid acceptance. In our subsequent discussion, we will be discussing on the communication of offer and acceptance.